Property management is a critical component of Arizona's real estate industry, combining fiduciary responsibility, legal compliance, and day-to-day operational oversight. This module explored the laws, practices, and ethical duties that define professional property management under Arizona law, including the Arizona Revised Statutes, ARS section, Title 32, Chapter 20, the Arizona Residential Landlord and Tenant Act, ARS, Section 33-13018CQ, and the Arizona Administrative Code, AAC, Title 4, Chapter 28. Understanding these principles ensures that licensees act within the scope of their authority, maintain client trust, and protect the public interest. The module began by defining the special agency relationship that exists between a property manager and a property owner. This relationship, established through a written property management agreement, creates fiduciary duties of loyalty, disclosure, accounting, confidentiality, obedience, and reasonable care. Under ARS Section 32-2173, no licensee may manage property without a written agreement that outlines duties, authority, and compensation. Property managers act as special agents because their authority is limited to specific management activities defined in the contract, such as collecting rent, coordinating maintenance, and enforcing lease terms. A property management firm is a brokerage licensed by the Arizona Department of Real Estate, ADRE, that handles rental property operations for compensation, while a rental agreement is a contract between landlord and tenant that defines possession rights, rent amount, and lease terms. These foundational concepts distinguish property management as a specialized practice area requiring strict adherence to statutory and ethical rules. The module also highlighted the differences between residential and commercial property management. Residential management typically involves apartments, condominiums, or single-family homes governed by the Arizona Residential Landlord and Tenant Act, ARLTA. Commercial management, on the other hand, involves retail, office, or industrial spaces where leases are more complex, often negotiated individually, and not subject to ARLTA. Examples of commercial property management include shopping centers, business parks, mixed-use developments, and office buildings. Each property type demands unique expertise in lease structure, maintenance obligations, and tenant relations. Short-term rentals, such as vacation homes or Airbnb-style properties, were examined in the context of license exemptions. A license is not required for individuals who manage their own property or short-term rentals of less than 31 days, provided they do not act on behalf of others for compensation. However, when a person manages short-term rentals owned by others, they must hold an active real estate license and comply with local ordinances regulating short-term rental activity. A central portion of the module focused on the Arizona Residential Landlord and Tenant Act, ARLTA, which governs residential leasing relationships. The act regulates security deposits, rental fees, landlord access to property, and tenant rights. Landlords must provide at least 2 days' notice before entering a rented unit to show it to prospective tenants or buyers. Upon lease termination, landlords must return the tenant's refundable security deposit and provide an itemized list of deductions within 14 business days, as required by ARS, Section 33-1321-D. Violations can result in financial penalties and possible legal action. The ARLTA is enforced through Arizona's judicial process, meaning that disputes are resolved in court rather than through ADRE, and the act does not apply to commercial properties. The module then revisited the fiduciary duties of licensees by addressing the proper handling of trust accounts. Under ARS, Section 32-2174, brokers must maintain a separate trust account for client funds, such as rents and security deposits. All funds must be deposited promptly, accurately accounted for, and reconciled monthly. Commingling client funds with operating funds is strictly prohibited and can result in disciplinary action under ARS Section 32-2153. Next, the discussion turned to the Property Management Agreement, which governs the legal relationship between the property owner and the broker. It must be in writing, signed, and clearly outline the duties, authority, fees, and termination procedures. Upon termination, property managers are required to transfer all client funds, provide a final accounting, and deliver records to the owner or new management company within a reasonable timeframe. All copies of documents must be retained for 5 years from the date of the last activity in compliance with ARS Section 32-2151.01a. The record's retention requirements for property managers were further emphasized as a cornerstone of compliance. Brokers must maintain accurate ledgers, leases, receipts, disbursements, and correspondence to ensure audit readiness and transparency. Records may be kept electronically, provided they are secure, unaltered, and retrievable during an ADRE inspection. The case in Re Walker Realty and Management, ADRE 2012, reinforced the importance of maintaining detailed and accessible property management records to avoid disciplinary action. The final section addressed the lawful use of finder fees for apartment tenants. The payment must be in non-cash form, such as a rent credit or gift card, and cannot involve any real estate activity, such as negotiating leases or collecting payments. Finder fees are legal only when used as limited marketing incentives, not as commission substitutes. Overall, this module emphasized that successful property management in Arizona requires balancing business operations with strict legal and ethical compliance. From establishing fiduciary relationships to managing trust accounts and maintaining records, every action must align with statutory requirements and professional standards. Key points to remember: property management creates a special agency relationship governed by written agreements under ARS Section 322.173 through ARS Section 32-2176. Property managers must comply with trust account laws. ARS Section 32-2174 and maintain detailed records for 5 years. The Arizona Residential Landlord and Tenant Act regulates residential leases but excludes commercial properties. Finder fees for tenants are lawful non-cash. There is no cap, and a tenant may receive multiple finder fees each year. Proper documentation, ethical conduct, and adherence to ADRI standards protect both the client and the licensee. Discussion prompts. Why is the property management agreement considered a special agency relationship rather than a general agency relationship? Answer: because it limits the broker's authority to specific management duties outlined in the agreement rather than granting full authority over all owner decisions. Why does the Arizona Residential Landlord and Tenant Act exclude commercial leases? Answer: because commercial leases involve complex negotiations and are typically between sophisticated business entities rather than individuals needing statutory protections. What is the legal significance of maintaining property management records for 5 years? Answer: it ensures compliance with ARS Section 32-2151.01a and ARS Section 32-2175 provides documentation for audits or legal disputes. Closing remarks. Property management is both an art and a science, an intricate balance between client service, legal precision, and ethical integrity. Each fiduciary duty, trust account deposit, and contract clause represents a safeguard for the client's interests and the licensee's professional standing. Arizona law provides a clear framework for managing residential and commercial properties, and when followed diligently, it enhances transparency, prevents misconduct, and elevates public trust in the real estate profession. The competent property manager operates not only as a business operator, but also as a guardian of the law and advocate for fairness within Arizona's housing market.